Good evening. This week's tutorial is designed for managing agents and trustees who deal with homeowners associations that are companies. We have a new Companies Act, Act number 71 of 2008. Although the year is aged, it has just come into force. It came into operation on the 1st of May 2011, and it is arguably the most important statute that exists from a commercial law perspective. I'm going to, and this is the purpose of this is just to give you an overview. I'm going to give you some highlights, but bear in mind that coming from a Paddocks Club perspective, I will be concentrating on non-profit homeowners associations. That's the central core of my interest. I'll be looking at accessibility, at the structure of the Act and of companies to a limited extent. I will give you a quick breakdown, which is largely some suggested reading, and then I'll give you a quick summary. Please bear in mind that this is just an introduction to the new Act, not a detailed treatment. The highlights of the Companies Act, Act 71 of 2008, are that there is one act for all types of companies. So closed corporations, a minor sort of company that was created some time ago, they're all part of the same thing. One act covers all types of companies. There is a simpler structure put in place. You only really have two types of companies, profits and non-profits. Now there are all sorts of profits, but for our purposes, we're simply look at a homeowners association that was formed under Section 21 of the old Act. It's a non-profit, so it's quite simple. All companies will now have a single memorandum of incorporation. No more will there be articles and a memorandum and separate documents. So there will be one document for all new companies. Directors will be more strictly responsible. Their responsibilities and liabilities are more clearly set out. There is a requirement for plain language in company communications. There is a provision for electronic communication and online meetings, which I think is very welcome and timely. There's an introduction of a variant of what overseas has become known as the business judgment rule for directors, and where people, let me talk about that business judgment rule for a second. We haven't adopted it exactly in the same way as it applies in Canada and America and elsewhere. Ours is a variant of that business judgment rule. In essence, a director is protected against any action for breach of his or her duties of care, skill and diligence, and the duty to act in the best interests of the company, as long as the director can satisfy the following requirements: that the director has taken reasonably diligent steps to become informed about the matter. No covering your eyes and signing on the bottom corner of the piece of paper. You have to take steps to be informed. If you don't understand, get informed. Secondly, there either has to be no conflict of interest whatsoever, or if there is a conflict, the director must have followed the quite strict rules on dealing with conflicts of interests. And then finally, there must have been a rational basis in the director's mind and in reality for the decision that was taken. In other words, the director must believe and must have reason to believe that the decision was taken in the best interests of the company. In doing in their business, the directors are entitled to rely on information that's given by people such as employees and auditors and others, but then they must have a good reason for believing that that person is competent and knows what they're doing. Right, let's look at what I've called accessibility. This Act is drafted in plain language. It is much easier to read than the previous Companies Act. It has only 225 sections. Now it sounds a lot, but bear in mind the last one had over 400 sections, and everything's quite clearly labeled. It's quite nicely set out. Everything that you could possibly want is available at the new website. CIPC codes are. Go and have a look around. It's well done. Everything is available for download. It really is. It's a pleasure to see a government website done quite so well. The Act and regulations are also available in the Paddocks Club library under HOAs. So if you don't want to put various acts together and that sort of thing, it's all been done for you there. I see that already, although it only came into operation yesterday, that there is a rush of offers, some of them entitled with dramatic words, phrases such as sink or swim, come to our seminar. There'll be lots and lots of seminars on the new Companies Act. It's going to be big news for some time. It's a major change in something that's very important to lawyers and accountants, and everybody wants to explain it to you. Some of those explanations come with an enormous price tag. Others, and many that you can get from the government itself, will be free. So have a look, choose what you want. If you're the sort of person that likes to go with your company to a lot of things, I'm sure you'll be able to pay somebody to take you through this. But I'm sure also that if you're clever and use the internet, you'll be able to find quite a lot of people giving you this information for free. There will also be a lot of people saying, oh, you've got to bring your documents in, we've got to have them checked because they will need to be changed. Be careful before you buy any wooden tickies. Just make absolutely sure that you do have a need. I'm not saying for a second anyone can ignore this new Companies Act. You can't. You have to get informed. You have to understand it, but it doesn't have to cost you a fortune, and you don't have to have all your documents changed because of it. There is a fundamental shift in corporate governance principles behind this new act, and you do need to get to grips with that. So let's just have a quick look at the structure. The act is broken down into 9 chapters, some of which are not applicable at all to non-profits, so that already gets a lot easier. There are 5 schedules to the act, and then there are regulations, quite extensive regulations, which are broken down into 8 chapters, and there are 3 annexes to the regulations. There's also a whole group of forms and notices which help people apply and make application and get permission and all that sort of thing. There is a quick diagrammatic for the people who like pictures. There is how the thing is laid out. There is a preamble. There's chapter 1, chapter 2, chapter 3, 4 and 5. You don't need to worry about too much. 6, 7, 8 and 9, and the titles are there, but it'll get easier to read a little further on. There are then the schedules to the act, and there's a group of regulations which also have their own annexes, and finally there are the forms and precedents. It looks like a lot, but actually once you get hold of it, don't be scared of this thing. Lawyers don't know anything about it, accountants don't know anything about it, managing agents don't know anything about it, but they're all starting on more or less an equal footing with a new act designed to be simple and straightforward. So don't be scared of it, get in there, read it, and I'm going to give you hints as to what I think you should read, just to get you up to speed fairly quickly. In the preamble in chapter 1, I draw your attention to the definition section, always important in any legislation. Go through the definitions. You may find that some will never be applicable to you, but then at least you've looked at them and you can cross them off. But those that are important, those are very important, because of course they apply to everything else you read in the Act. In Part B, have a specific look at 8 and 10. 8 gives you the various categories of companies. Once you've read it once, you'll understand it, and there'll be no difficulty ever again, but you just need to understand it. 10, again, a once-off exercise. You go and have a look at the modified application of this particular act with respect to non-profit companies. If you're looking at it in the context of an HOA, Section 21 company, you look at that, you understand it once, and you never have to look at it again because you'll understand, you will have marked it up. So you're knocking these things down like Skittles now. Then in Chapter 2, there are various parts, but have a specific look at Part C. It introduces transparency, accountability, and integrity at a greater level for companies. You'll see that specifically sections 24 to 34 are ones that I think you should have a look at. And if you just cast your eye down the sort of subjects that they deal with, you'll see that this is important stuff you need in order to run any company, to understand what the accounting records are that must be kept, financial statements. Incidentally, on the question of the annual return in 33, there was some question in people's minds as to whether the ex-Section 21 companies would have to render annual returns, and they have come out with a specific notice making it absolutely clear you do. So don't think that things aren't going to change. As I've already indicated, they will change. But for the better, and things will not be that hard. In Chapter 2, which deals with formation, admin, and dissolution, of course, you're not forming a company if you're just looking at an existing HOA, although the formation procedures have been streamlined and they're much, much easier than they were before. But here, have a look at the governance of companies. Specifically, I suggest you read 57 to 68 fairly carefully. You'll see they're all operational issues within the context of the company, and that's something you should know. A little further on, 69 79 to 78, again, board meetings, standards of directors' conduct, all these things. These are important, and you really should read these carefully. And they're not hard to read. They're in very plain English. You're not going to have to make notes on the side saying this means that. All you're going to be doing is underlining certain words or highlighting them, whatever your preference is for remembering. Then when you get to chapters 3 to 7, this we can take quite quickly. Chapter 3, enhanced accountability and transparency, will probably not apply in most cases. Chapters 4 and 5 definitely don't apply. No HOA is going to be making public offerings. It can't. It doesn't have company securities. It won't be entering into fundamental transactions, takeovers, mergers, that sort of thing. So there's a huge swathe of the Act of these fewer chapters that you can that you don't have to worry too much about. Business rescue, which is the new word for judicial management, or the replacement concept, much better. It's going to be tightly controlled. It's going to, I think, work an awful lot better. It puts us on par with other overseas jurisdictions with a set of processes that have proved themselves in the real. So obviously it's unlikely that an HOA will get into a situation which would have required judicial management, now requires business rescue, but it is possible. So you should know that it exists, but I wouldn't think this would be your first reading. Chapter 7, remedies and enforcements, worth a quick look. In part 8, specifically the right to seek specific remedies. I suggest you look at 162 and 163. I think these are important. In 8 and 9, I suggest in 9, specifically part A, look at 214 to 217, dealing with penalties. I did mention that we're out of the criminal penalties. We're now in a realm of civil penalties, much more appropriate for what are fundamentally civil issues. Then the schedules to the Act, 1 and 5, have a good look at them. I've given you the headings to all of them. 1 specifically deals with non-profits, and you really should, if you can read anything really carefully, Schedule 1, give your attention to that. Schedule 5, also worth looking at carefully. The regulations, quite a big set of regulations, but again broken down nicely, and again you'll see correspondence between the Act and the regulations. The regulations spinning out, giving you more detail to the fundamental provisions in the Act. So have a look at chapters 1 and 2, and you'll see that I've highlighted in part C of chapter 2 regulations 21 to 30, which I think are useful. In chapters 3 to 8, again you're moving pretty quickly here. Chapter 4 and 5 you don't need to look at all, for the same reason you didn't have to look at those other chapters of the Act. Chapter 6, business rescue, 7, we're following more or less the same thing, and then there are the annexes, which don't probably deserve your attention right at the beginning. Let's have a quick review of that structure. There it is in diagrammatic form once again. It is fairly straightforward, and really don't be scared of this baby. Get into it, understand it, and we'll be much better for it. In Paddocks Club, it's all there in detail. You can cut and paste, do what you like with that, and you can move through it and take the bits out that you want. So I encourage you to go there and have a good look at it. This thing is here to stay. It's going to make a big difference. Get to know it. Thank you very much for your time. Thank you for watching this Paddocks Club tutorial, and I hope to hear from you in the discussion forum.